Hello everyone, this is lecture 4 on the Supreme Court rules. We are discussing part 1 of the Supreme Court rules and this is order 4. Order 4 has total 23 rules. That's why I have divided into two different videos. This is video 1. In this, we will discuss rule 1, 2, 3 and 4. So let's start. Order 4 is about advocates. Now rule 1 has 3 sub-rules. Rule 1, sub-rule A. Subject to the provisions of these rules, an advocate whose name is entered on the roll of any state bar council maintained under the Advocates Act 1961 as amended shall be entitled to appear before the court. So rule A provides for entitlement. I'm an advocate and my name has been entered on the roll of any state bar council. That alone gives me entitlement to appear before the Supreme Court. Now let's see what is proviso. Proviso 1. Provided that an advocate whose name is entered on the roll of any state bar council maintained under the Advocates Act 1961 for less than 1 year shall be entitled to mention matters in court for the limited purpose of asking for time, date, adjournment, and similar such orders, but shall not be entitled to address the court for the purpose of any effective hearing. So, Rule 1, Sub-Rule A was entitlement. Now, Proviso 1 attached to this Sub-Rule A is restriction. So, Proviso 1 imposes a restriction upon those lawyers whose name have been entered on the State Bar Council roll for less than 1 year. These lawyers are entitled to mention matters in the court for limited purposes. Now let's see what is Proviso 2. Provided further that the court may, if it thinks desirable to do so for any reason, permit any person to appear and address the court in a particular case. Proviso 2 basically paves a way for this any person. There is a particular case in which the court is of opinion that Mr. X should be allowed to appear. Court feels that it is desirable in the interest of justice that he may be allowed to appear in this particular case. So this any person, Mr. X, may be allowed in terms of Proviso 2. Now let's see what is Sub-Rule B. Sub-Rule B provides that no advocate other than the advocate on record for a party shall appear, plead and address the court in a matter unless he is instructed by the advocate on record or permitted by the court. Now let's come to Rule C. What is this? Well, it relates to 3 matters. See, in petitions or appeals which have been received from jail or a matter filed by a party in person or where a party in person as respondent is not represented by an EVA. In these 3 matters, Sub-Rule C has to be applied. Let's read it. In petitions or appeals received from jail or a matter filed by a party in person or where a party in person as a respondent is not represented by an advocate on record, the Secretary General or Registrar may require the Supreme Court Legal Services Committee to assign an advocate who may assist the court on behalf of such person. So it is basically a duty assigned to Secretary General or the Registrar. What is the duty? Duty is that you as a Secretary General or Registrar require the Supreme Court Legal Services Committee to assign an advocate. And this advocate will assist the court on behalf of these 3 persons, these 3 matters. Now there is a proviso attached to this Sub-Rule C. It is basically the procedure, restrictions, requirements for a party who is appearing in person. Let's see what does it provide. Provided that whenever a party wants to appear and argue the case in person, he or she shall first file an application along with the petition seeking permission to appear and argue in person. So firstly, move an application before the court, before the registry and seek permission to argue. Then the application shall indicate reasons as to why he or she cannot engage an advocate and wants to appear and argue in person. Secondly, indicate your reasons. Why are you avoiding advocate? Why are you not engaging an advocate to put up your case? Why do you want to appear in person? Indicate your reasons. Then thirdly is basically his willingness. He will have to clearly write it that I am willing. See what it says. And if he is willing to accept an advocate who can be appointed for him by the court. Your willingness has to be very clear, because court is going to appoint an advocate which it personally thinks fit to put up your case. So your willingness has to be in that application. Very clear willingness. Now fourth and last, what it is. Such application shall, in the first instance, be placed before the concerned registrar to interact with the party in person and give opinion by way of office report whether the party in person will be able to give necessary assistance to the court for proper disposal of the matter, or an advocate may be appointed as amicus curiae. So the last fourth point is duty of the registrar. Mr. Registrar, you will have to sit with the party. You will have to interact with him in person. And with that interaction, you will have to give opinion by making an office report. Your opinion will be about whether the party in person will be able to give necessary assistance to the court. And if you think that party in person will not be able to give necessary assistance to the court, then for proper disposal of the matter, an advocate may be appointed as amicus curiae. And then lastly, if the application is allowed by the court, then only the party in person will be able to permit it to appear and argue the case in person. So if these four procedures are fulfilled, you have made an application seeking permission, you have indicated reasons why do you want to appear in person and why are you not engaging an advocate, your willingness, then lastly duty of the registrar, that the registrar has sat with the party who is willing to appear in person and he is satisfied that he can assist the court in disposal of the matter, or if he is satisfied that the party will not be able to assist the court for the proper disposal, then an advocate may be appointed as an amicus curiae. Now let's come to rule 2. See, rule 2 is about designation as a senior advocate. Rule 2, sub-rule A reads as, the Chief Justice and the judges may, with the consent of the advocate, designate an advocate as senior advocate if in their opinion, by virtue of his ability, standing at the bar, or special knowledge or experience in law, the said advocate is deserving of such distinction. Then what is the second Roman number in this explanation? Well, it provides for tribunal. Tribunal includes any authority or person legally authorized to take evidence and before whom advocates are, by or under any law for the time being in force, entitled to practice. Explanation 3. Junior. Junior means an advocate other than a senior advocate. So these three are the explanations. Now let's see what is sub-rule C. Sub-rule C is duty of the registrar. Let's see. Upon an advocate being designated as a senior advocate, the registrar shall communicate to all the high courts and the secretary to the Bar Council of India and the secretary of the State Bar Council concerned the name of the said advocate and the date on which he was so designated. So this is duty of the registrar. Now what is rule 3? Rule 3 provides that every advocate appearing before the court shall wear such robes and costume as may from time to time be directed by the court. What is rule 4? Any advocate not being a senior advocate may, on his fulfilling the conditions laid down in rule 5, be registered in the court as an advocate on record. So this is all for this video. In the second part, we will discuss the remaining rules of order 4. Thank you very much.